Hello everyone, my name is Heather Holliday and this is my oral presentation for NURS 916 over Patient Confidentiality and Americans with Disabilities Act. First, let's begin with patient confidentiality. This can also be termed patient privacy. Patient privacy is not only extremely important for the patient to understand, but for nurse practitioners and other healthcare providers to understand and comply with. Nurse practitioners and other healthcare providers are required by federal law to protect patient confidentiality and privacy. Congress mandated the Department of Health and Human Services to create a set of rules governing privacy in healthcare. As a result, the Department of Health and Human Services developed the Health Insurance Portability and Accountability Act of 1996. This is better known as HIPAA. Patient information that must be kept confidential was termed Protected Health Information, or PHI. This protected health information is to include any individual identifiable health information that is in any form, whether that is electronic, paper, or oral. Information that is included is information such as demographic data, past or present health conditions, past or present future healthcare payments, name, date of birth, address, and much more. You might ask who and what must comply with HIPAA. According to the Office of Civil Rights, an individual, organization, or agency that meets the definition of a covered entity must comply with the rules and regulations set by HIPAA. Covered entities include a healthcare provider, a health plan, and a healthcare clearinghouse. If a place or person meets the definition of a covered entity, they must assure the following occurs. They must appoint a privacy officer, assess the office, hospital, or facility for potential breaches of patient safety, issue policies regarding handling and protection of patient information, conduct staff training for staff about policies, monitor office and facility procedures for compliance of policies, get patients to authorize in writing any release of their individually identifiable information for marketing purposes, notify patients in writing of their rights under the rules, and make a good faith effort to get patients to sign an acknowledgement that they have received notice of their rights. Like any other healthcare provider, a nurse practitioner has basic requirements they must follow under the privacy rule for HIPAA. The requirements are: nurse practitioners and other healthcare providers are restricted to conveying the minimum necessary information about patients to achieve a desired healthcare outcome. To release patient information for marketing purposes, the nurse practitioner must explain to the patient what information will be used, who the information will be disclosed to, and when the information will be disclosed. The provider must also authorize in writing the patient's consent for allowing information to be released. Nurse practitioners may disclose health information to agencies such as the Centers for Medicaid and Medicare, CMS, without consent from the patient. No consent is needed from the patient if the nurse practitioner is reporting victims of abuse, neglect, or domestic violence when the state law mandates reporting. Nurse practitioners in general must obtain authorization from the patient to release psychotherapy notes for further treatment options, payment, or healthcare operations. Patients may disclose their entire record at any time. Nurse practitioners must notify patients on how their medical records may be used and information on how the patient can access their own healthcare information. Individuals have no rights to 3 types of information: psychotherapy notes, information compiled and possibly used for criminal litigation, and certain clinical lab information covered by the CLIA. Breaches of patient confidentiality are taken very serious by the U.S. Department of Health and Human Services. If a breach is suspected or found within a covered entity, notification of the breach must be reported to the facility's privacy officer and their Secretary of Health and Human Services breach of unsecured protected health information. Notification obligations differ between entities based on the individuals the breach affects. The two different breach reports include 500 or fewer individuals affected by the breach or 500 or more individuals affected by the breach. If the number of individuals affected is unknown at the time of the report, the breach should still be reported, the estimated number of individuals affected given, and updates should be provided as knowledge is gained on the particular breach. Any additional information found on a particular breach can be added as an addendum to the initial report. Breaches can be reported at the website listed on the slide. Failing to comply with HIPAA can result in a number of consequences depending on the severity of noncompliance. The U.S. Department of Health and Human Services Office of Civil Rights has the responsibility of reviewing breach cases and determining if the covered entity has failed to comply with HIPAA. If the covered entity is found guilty, consequences such as corrective action, resolution agreement, civil violations, or criminal penalties may occur. For civil violations, the Secretary of Health and Human Services has discretion in the amount of the penalty based on the nature and the extent of the violation and the nature and extent of the harm resulting from the violation. Civil penalties can be avoided if the covered entity corrects the violation within 30 days. This is true unless the violation was willful neglect. Criminal violations regarding HIPAA are handled by the Department of Justice. On this slide, you will find civil penalties for HIPAA violations. They are found as the conduct of the violation and the penalty that would be awarded for that violation. Please review the information on this slide. Criminal penalties are as follows. If a covered entity or individual who knowingly discloses identifiable health information could face up to a $50,000 fine and imprisonment up to 1 year. Offenders who violate under false pretenses have up to a $100,000 in fine and up to 5 years of imprisonment. Offenders who violate HIPAA with the intent to sell, transfer, or individually use protected health information for commercial advantage, personal gain, or malicious harm could face up to a $250,000 fine and up to 10 years of imprisonment. On this slide, you will find my pros and cons to HIPAA. Please review this slide for further information. Now we will switch topics to the Americans with Disabilities Act. In 1990, the Americans with Disabilities Act was stated into law. This act, under Title I, prohibits any private employer from discriminating against qualified individuals in hiring, firing, advancement, compensation, job training, and conditions of employment. The Americans with Disability Act protects individuals with disabilities under employment, transportation, public accommodations, communications, and government activities. Under the ADA, a disabled person is one who has a physical or mental impairment that substantially limits one or more major life activities. Disabilities include, but are not limited to, walking, talking, bending, seeing, hearing, learning, breathing, and reading. A disability also includes a person who may be disabled if he or she has a history or current disability such as cancer, digestive and bowel disorder, bladder disorder, endocrine disorder, neurological disorder, respiratory disorder, and more. This act applies to employers with 15 or more employees and also agencies and labor organizations. According to the United States Department of Labor, the Americans with Disabilities Act is enforced by 4 federal agencies. Those agencies are the Equal Employment Opportunity Commission, the Department of Transportation, the Federal Communications Commission, and the Department of Justice. Title I is enforced by the Equal Employment Opportunity Commission. If an individual believes that they have been discriminated against based on a disability, a claim may be filed to the Equal Employment Opportunity Commission. The claim must be filed within 180 days of the alleged discrimination. Under the ADA, employers who have the means necessary must make accommodations for an employee hired that has a legal disability. The accommodations include, but are not limited to, making an existing facility used by employees readily accessible and usable to a person with disabilities, job reconstruction, such as modifying a work schedule or reassignment to a vacant position, and acquiring or modifying assistive devices, examinations, training materials, policies, and also providing a qualified interpreter. Employers do not have to make accommodations if it causes undue hardship, which is defined as an action requiring significant difficulty or expense when considering employer size, financial resources, and nature or structure of its operation. An employer does not have to provide accommodations to a disabled employee unless asked for by the employee with the legal disability. If an employer should violate Americans with Disabilities Act, an individual may file a claim with the U.S. Equal Employer Opportunity Commission or the Department of Justice. The Department of Justice seeks monetary damages and civil penalties. The civil penalties do not exceed $55,000 for the first violation. However, any subsequent violation would result in a $110,000 fine per additional violation. The impact of the Advanced Practice Registered Nurse role and the Americans with Disabilities Act. The nurse practitioner may have to verify a diagnosis related to a disability for an individual attempting to seek employment or work accommodations. Nurse practitioners might have to adjust to accommodations brought into their place of work because of another employee needing such accommodation for disability. Nurse practitioners with a disability themselves can receive work accommodations without discrimination. Nurse practitioners should be educated of the Americans with Disabilities Act so that they may educate their patients on this act if diagnosed with a disability. Education and advocating is an essential part of nursing. The pros and cons to the Americans with Disability Act of 1990. Americans with disability no longer need to worry about finding employment or being turned away from a job if qualified related to disability. A diagnosed disability can allow the individual to obtain accommodations at work, this making it easier on them to work and have a safe environment. The Americans with Disability Act has funds available for employers to make such accommodations for an employee with a disability. And employers also are accountable for any type of discrimination against an employee with a disability, whereas this might not have been the case before the Americans with Disability Act was stated as of 1990. Cons. Employers might have to deal with frustrations from other employees who have to adjust to such accommodations, and these accommodations might inconvenience employers related to time, resources, and finances. Listed below are my resources that I used to complete this presentation. Please let me know if you have any questions. Thank you.